Morning, everybody. Welcome to this hearing in relation to the Kauwhata rezoning proposals. I see there's a number of, or one or two people that may not be that familiar with these processes. So we will just spend a little bit of time on a few formalities and just so that people understand how today works. What I'm going to do first, though, is ask the hearings panel just to briefly identify themselves so people know who's in the room. I'll then make a couple of, not announcements, but run through a few details so that people that aren't that familiar with the process know how we're operating. And then we'll ask people that are submitters or observers just to briefly introduce themselves. And when they do that, if there's anything of a procedural nature that they wish to raise, they can do it at that time. Thanks. So my name is Phil Mitchell. I'm the hearings chair for today. I'm an independent planning commissioner from Auckland. And if I could ask the rest of the panel to briefly introduce themselves, please.
Good morning, I'm Jan Sedgwick. I'm a Waikato District Councillor, but appointed to this role as an independent commissioner. Good morning.
Good morning, Janet Gibb. I'm an independent commissioner and Waikato District Councillor.
I'm Diane Fulton. I'm an independent commissioner and I was a former Waikato District Councillor.
Morena Linda Teaho, Independent Hearings Commissioner.
Morena koutou, Will Marg, Independent Hearing Commissioner.
Morena, Paul Cooney from Tauranga, Deputy Chair and lawyer.
Thanks, everybody. Just in terms of how today runs, some of you will have heard this before because you've been to a number of our hearings, so apologies for any repetition. But we have read the various submissions, statements of evidence, the Section 42A report, so on and so forth. So we're asking people that are presenting to us today to provide us with a 10-minute or thereabouts highlights package, with the emphasis being on what the problem is they're seeking for us to address, and equally importantly, what they want us to do in terms of how to address the issues that they're raising. We're not expecting, and it's not helpful to us, for people to read out vast screeds of information that's already been provided. We're really looking for people to do, as I've said, which is to highlight the issue that's needing to be addressed and how that might best be done from the submitter's perspective. At the end of each presentation, the panel may ask any questions of clarification. I would stress, though, especially for those people that aren't familiar with this process and perhaps feeling a little bit uneasy or nervous, please don't be. We're simply here to listen to what you've got to say. If there's something that we don't understand, or if there's something that we'd like a bit more information about, we'll ask you. For those of you that watch plenty of TV and legal dramas and so forth, think this is an opportunity to make people look foolish. It isn't. It's simply a matter of us hearing what you've got to tell us, us asking any questions if we don't understand, and then that's it. So for those of you that are new to this, please try and be as relaxed as you can be in the circumstances. So I think by way of introduction, that's all we need to say, but if we could just go around the room, please, if people could introduce themselves, and if there's any questions or queries about the procedure, then that would be a good time to raise them. Thanks.
I'll start off. So, Morena, Jane McCartney here, Section 42A writer, not Given, I'm the Chief Executive. So just disregard Given's name this morning.
Thank you, Ms. McCartney. Good morning.
Morena, Sandra Kelly for the Waikato District Council.
Good morning, everyone. Adam Jelly, Planner, Assistant Counsel.
Good morning, everyone. Engina from Birch Surveyors Hamilton, just observing.
Thank you.
Can you hear me?
Yes, we can.
Juliet Sunday, ratepayer.
Morning.
Morning, everyone. Sam Shuker, Birch Surveyors, appearing on behalf of Z&Z Developments a bit later on.
Thanks, Mr. Shuker.
I'm Aaron Graves, Civil Plan Consultants, appearing on behalf of Hugh Green Limited.
Thanks, Mr. Gray.
Good morning, I'm John Duffy, appearing on behalf of Lakeside Developments. We simply want to record that we are happy and are supportive of the 42A report, happy to answer questions, otherwise we'll withdraw.
Thanks, Mr. Duffy.
Good morning.
We could hear you for a moment there, Mr. Dawson, but
Good morning.
Oh, yes.
yeah, we're having trouble hearing you. Your connection doesn't seem too good, but we do know who you're appearing for, and we've noted that. Thanks. All right, I think without further ado, we'll commence. What I will ask you to do, though, if it's not your turn to speak, if you could just mute the system so that we can't hear you and there's something running around in the background or whatever, and if you could also turn your video off, that way it just preserves the bandwidth for those that are speaking. You'll still be able to hear and see us, it's just that we won't be able to hear and see you. We'll be able to see the people that are presenting at the moment. So, Ms. Sunday, there should be if you hold your mouse over the screen, on my screen, it's the bottom left. There's a little microphone that says mute, and there's a little video camera that says stop video. There you go, you've cracked it. All right, thank you. I think we're ready to commence the hearing proper, and we commence with you, please, Ms. McCartney, presenting the Section 42A report. I should also say that we don't stick to the fairly strict 10-minute time frame for the Section 42A report author. That's simply because, unlike the other submitters who have simply got to address their own statement, Ms. McCartney's got to provide her view on the package as a whole. So she needs a little bit more time than that. So thank you, Ms. McCartney. Just when you're ready, thanks.
Thank you. Can I just check before I start the opening statement that I'll read to now? Did the panel receive that yesterday?
Yes, thank you.
Okay, thank you. I'm hoping to take no more than 20-25 minutes. So my key aim really is just to cut to the chase. So
it would be good. I think it would also be helpful if either you or Ms. Kelly is able to put the zoning map or the proposed district plan map on the screen as you're going through this, so that everybody can see specifically the locations that you're referring to.
Okay, thanks, Sandra. If you could help me out there, that would be great. Okay, so I'll kick away. My name is Jane McCartney. I'm the author of the Section 42A hearing report and rebuttal evidence, which have addressed the submissions received on the topic of zoning at Kauwhata. In this opening statement, I provide a brief summary of Kauwhata as a major growth settlement in Waikato district, key differences in zoning between the operative and the proposed plans, the main topics raised by submitters, and the unresolved issues raised by some of the submitters who wish to be heard today, which I will address in the order of their appearance. So firstly, in respect to Kauwhata as a major growth settlement in Waikato district, as at the date that I finalised my Section 42A hearing report in April this year, Kauwhata contained an approximate population of 2,944 households. These statistics and the existing zoning pattern are largely the result of two processes which occurred on top of the operative zonings from the last district plan review. The first process was the introduction of the Kauwhata structure plan into the district plan in 2009 via variation 13. And the second process was the introduction of the lakeside development into the district plan in 2018 via private plan change 20. In summary, variation 13 provided for additional housing in a new Kauwhata West living zone in between State Highway 1 and the main trunk railway, a new Te Kauwhata ecological living zone in close proximity to the Whangarina wetland and Lake Waikare, expanded consents of the light industrial, business and recreation zones, a mixed use policy overlay, a mixed use policy area overlaying part of the town centre, new ecological corridors around the margins of the Whangarina wetland, new urban design guidelines, and a new framework of objectives, policies and rules. Variation 13 ran in parallel with a notice of requirement for a new heavy traffic bypass. The proposed Te Kauwhata West Living Zone was appealed to the Environment Court by the Te Kauwhata Action Group. This zone and its provisions were then confirmed by the court in 2012 and have been operative since 2013. While I consider that this zone's minimum net lot size of 650 square metres and minimum average net lot size of 875 square metres are now outdated, I also consider that the court's commentary on new zoning to provide for further growth at Te Kauwhata is relevant to this hearing topic and has assisted my recommendations on submissions. In this regard, both the court and Future Proof note that Te Kauwhata is important as a service centre for farming areas to the east and west and is strategically important in terms of accommodating increased growth between Hamilton and Auckland. The second process that involved Plan Change 20, Lakeside, resulted in 194 hectares of precinct plan that now forms a southern extension to the Te Kauwhata structure plan alongside Lake Waikare. It provides for medium and high density housing typologies, a community business hub, open space and a cultural and heritage overlay. PC20 was made operative on the 13th of July 2018 and all of its provisions were rolled over into the proposed plan without change when that was notified a few days later on the 18th of July 2018. A press release in June 2020 advised that Kauwhata and Lakeside's property developer, being Winton, had entered into a land supply agreement to deliver more than 1,300 homes at Lakeside over a 7 to 8 year period. More recently, I have been made aware of the Ministry of Education's land purchase in Lakeside and that a notice of requirement for a new primary school designation is expected to be lodged soon. Turning now to the key differences in zoning between the operative and the proposed plans. The zones for Te Kauwhata in the proposed plan are largely a rollover of the operative zones, although there are some key differences which involve firstly, the rezoning of a parcel of land within number 75 Te Kauwhata Road and two properties at 17 and 40 Scott Road from industrial to residential. I understand this is the result of Council's decision in 2016 to not proceed with the construction of a heavy traffic bypass and consequently remove that designation from the district plan. Secondly, the introduction of a new business town centre zone, which is to supersede the existing mixed use policy overlay that adjoins part of the main street. The purpose of this zone is to provide additional opportunities for small scale retail and above ground residential developments. Thirdly, the amalgamation of the 4 operative residential zones into a single residential zone, the Te Kauwhata West Living Zone and Te Kauwhata Ecological Zone, have become overlays termed the Te Kauwhata West Overlay and the Te Kauwhata Ecological Overlay. These overlays sit above the proposed residential zone and are spatially defined on planning maps. Both overlays provide the link to specific provisions in Chapter 16 for the residential zone, which were addressed in earlier hearing 10. In respect to the country living zone, the extent of this has been rolled over into the proposed plan without change, and the minimum lot size of 5,000 square metres also remains unchanged. No village zone is proposed in Te Kauwhata. Turning next to the main topics raised by submitters. This hearing has involved 30 original submissions and 30 further submissions. Approximately half of the original submissions support the notified zonings. The remaining half request rezonings that would increase the spatial extent of the residential, country living and business zones and reduce the extent of the business town centre zone. Some request minor amendments to zone extents to align with defendable boundaries, such as drainage channels or newly surveyed boundaries resulting from subdivision consents. In the interest of brevity, I do not repeat the reasons and recommendations in my section 42 report and rebuttal evidence here, as I consider these are self-explanatory. The only point I do wish to note here is that I discussed the issue of scope concerning the extent of the medium density residential zone with Kauwhata prior to finalising my rebuttal, and this was acknowledged by Mr. Cameron Wallace during Kauwhata's general presentation on the zone in the earlier hearing. Turning now to the unresolved issues raised by submitters for today's hearing. The first one concerns Z&Z Developments, who is the owner of the property at number 102 Travers Road. Mr. Sam Shuker will present today on behalf of Z&Z's request to rezone the currently undeveloped property at 102 Travers Road. This property is zoned country living zone in terms of the operative plan and proposed plan, and their original submission requests a village zone. Z&Z also request an amendment to Notified Rule 24.4.2, which is specific to subdivision in the proposed village zones located at Kauwhata and Tuakau. This rule requires village zone lots in these two locations to have a minimum net site area of 3,000 square metres, where no reticulation for water and wastewater exists, which can be reduced to 1,000 square metres when such reticulation does exist. The amendment sought by Z&Z involves a bespoke provision that would allow the creation of 1,000 square metre lots from their property. They consider that this lot size would result in a desirable transitional zone between the existing countryside living zone immediately to the north and residential zone immediately to the south. From my discussions with Mr. Shuker last week, he has confirmed that water reticulation already exists in Travers Road. However, wastewater connections for the requested 1,000 square metre lots would likely depend on a public line being made available within 114 Travers Road immediately to the south whenever a residential subdivision is created there in the future. As a result of my recommendation to reject the village zone and my suggestion that this site could be a candidate for rezoning to residential, Z&Z now seeks to change their relief. They now request that their property be rezoned to residential and also be included in the Kauwhata West overlay. These particular requests did not form part of Z&Z's original submission. From a housing capacity perspective, there would be benefit in developing residential size lots from Z&Z's vacant property. However, I am unaware of any submission that would provide scope to consider the merits of applying a residential zone. Mr. Shuker also suggests that if the original submission had requested a residential zone, then the opposing further submitters would have likely expressed the same concerns about density being higher than the existing countryside living zone. This group of further submitters include Mr. Searle, Ms. Sund, and Ms. Byers, who wish to speak this morning. I remain of the view that this suggestion is speculative because the residential zone is a different product from the village zone, and they have different environmental effects, including visual impact as a result of different housing densities. I do not believe that we can assume that there would be no party other than the existing opposing submitters who would have submitted on the basis that they too considered themselves to be potentially affected. In my view, a separate Schedule 1 process for either a plan change or variation is the correct statutory process to pursue the outcome of a residential zone now sought by Z&Z. This process would ensure that all affected parties are given a fair opportunity to participate. It could also rectify the situation where small areas of residential zoning encroach into 102 Travers Road from the property immediately to the south at 114 Travers Road. However, I've also reflected on my Section 42 recommendation. If Z&Z wishes to keep their village zone request on the table, that is, despite me preferring a residential zone as the most superior option from a capacity perspective, I need to make some judgment as to whether the requested village zone is more appropriate than the status quo country living zone. From a capacity perspective, it is clear that a village zoning and a potential yield of 23 lots from this property would be significantly greater than the 5 countryside living lots that have already been consented but not yet developed. Therefore, if the panel considered it necessary to provide even more freeboard capacity, particularly for the short term, accepting the submitter's request for a village zone would give better effect to the NPSUD, in my view. In saying this though, while the NPSUD directs that at least sufficient housing capacity be provided, this does not mean that development should be unfettered and allowed to occur at all costs. This is because the objectives and policies in the NPSUD, the Waikato Regional Policy Statement, and the proposed plan still require urban environments that are well functioning and integrated with existing developments. I consider that further comment from Mr. Sherpa on these aspects would assist the hearing panel's determination on these matters.
Ms. McCartney, I think it would be helpful if you could just highlight the area on the map. I know where it is. It's immediately adjacent to the residential zone, sort of on the northwestern edge of the village. But Ms. Kelly, could you make that map a little bigger, please, so that it's a bit more easy to read? Even a little bit bigger, please, and then move it down a bit bigger. And just move it across a little bit and down. I think that would be helpful. So I think if I could, well,
yeah,
either you or Ms. McCartney could just clarify for everybody the location of the property, please.
Yes, unfortunately, I can't put my finger on the screen, but Sandra.
I think what I might do, I might share the screen because I've got that same document open. Just bear with me for a moment. Won't be a minute. Just take me a second to open this.
Yeah. Unfortunately, Travers Road is not marked there.
No, it's not. You see the screen now?
Yes, so where your cursor is, if you just go down one. Yep, that's it. Yes.
There.
Yes.
Okay. Very good. Thank you. Sorry, I didn't mean to interrupt, but I just think it's important to for everybody in the hearing to know exactly where we're talking about.
Indeed.
Thank you.
That is all good. Thank you, sir. Right, so turning to Newly Limited, I thought it would be useful just for me to briefly explain the journey that submission 626 has had since its lodgement by Vineyard Road Properties almost 3 years ago. Actually, while I'm talking, Sandra, if you could perhaps just pull up Maybe my section 42A report.
I've got that open at the moment, Ms. McCartney. That's where I've got this figure from.
Okay. So we're talking about 3 titles at the end of Vineyard Road.
Yeah, that one's here, isn't it?
Yes, that's correct. So the original submitter, being Vineyard Road Properties, requested that the rezoning of various properties from country living to village. They also sought a minimum net site area of 2,000 square metre lots in the village zone, whether or not they are publicly reticulated. This particular submission attracted 20 further submissions, 2 in support and 18 in opposition. Hearing 6 for the village zone occurred in December 2019. While I did not participate in that hearing, my understanding is that Muirlee's legal counsel, Mr. Julian Dawson, then advised the panel that Muirlee had taken over submission 626 and that its geographic extent is now limited to Muirlee's 2 titles located at the end of Vineyard Road. So yeah, page 97 of my report just shows the reduced extent of that submission. Mr. Jonathan Cleese prepared section 42 report for the submission subdivision provisions in the village zone. His recommendation was for the general subdivision rule, Rule 24.4.1, to be amended so that village zone lots outside of Te Kauwhata and Tuakau require a minimum net area of 2,500 square metres rather than 3,000 square metres as notified. He also recommended a bespoke provision in this rule for Vineyard Road Estate in Te Kauwhata that requires a minimum net site area of 5,000 square metres. In my view, the recommended rule for this Te Kauwhata location has perhaps jumped the gun, as it can only apply if the land is rezoned from country living to village. Even then, this bespoke rule would not change in any, would not result in any change to lot yield here, because the operative and proposed subdivision rules for the country living zone already enable 5,000 square metre lots. I understand that Mr. Cleese had further addressed that matter at the hearing 6. Planning evidence has now been lodged by Mr. Nick Williamson on behalf of Muirlee. Much of this relates to potential lot yields if a village zone were to apply. His evidence provides examples of country living zone locations at Lake Rotokauri and Tamahere to illustrate difficulties in transitioning to urban densities due to existing development. I agree that it would be extremely difficult, if not impossible, to retrofit country living zone lots that are already developed, particularly when houses of considerable size and curtilage are located in the central part of the property. In these situations, my view is that the horse is already bolted. Mr. Williamson also cites Port Waikato as an example of an existing village zone, which he says is a much clearer path to doubling the density of this settlement based on a starting lot size of 800 square metres compared to a 5,000 square metre lot in the country living zone. However, I do not consider this example as useful. This is because Franklin District Council applied a village zone to areas in this settlement that were zoned for residential purposes by the former Raglan County Council. The operative subdivision rules for Port Waikato require a minimum lot size of 2,500 square metres because no public reticulation exists and this village is not identified as a growth area. I see the Muirlee land being in a different category from these examples. This is primarily because the total area of 22 hectares and 2 titles is vacant, therefore lending itself to a well-planned residential development that could deliver lot yields significantly greater than those that could be yielded in terms of either a country living zone or village zone. To illustrate this point, and assuming a developable threshold of 80%, subdivision of the 22 hectares could make full use of the extensive frontage to Vineyard Road and potentially yield 35 country living zoned lots based on the minimum lot size of 5,000, or 88 village zone lots based on the submitter's request for 2,000 square metre lots, whether or not reticulation exists, or 176 village zone lots based on the notified minimum of 1,000 where reticulation does exist, or 391 residential lots based on the notified minimum of 450. Mr. Dawson's legal submissions appear to suggest that I've raised a scope issue. However, I remain clear that the original submission explicitly requests a village zone formulae and also requests that this zone provides for a minimum lot size of 2,000, whether or not reticulation exists. This area compares with the notified minimum of 3,000 for non-reticulated sites and 1,000 square metres for reticulated sites for the village zone located in Kauwhata and Tuko. Just as an aside, I note that submission 110 from GD Jones has requested a minimum of 800 square metres for village zone lots in Kauwhata and Tuko, which was considered in hearing 6. Because that submission is specific to these two settlements, I do not consider that any person could reasonably contemplate such provision applying to a potential village zone in Kauwhata. My current view is that I need to consider Murali's submission in the same way as I have for Z&Z. That is, despite my view that a residential zone would give best effect to the MPSUD in terms of capacity, there needs to be a judgment as to whether the requested village zone is more appropriate than status quo of the country living zone. From a capacity perspective, a village zone would provide even more freehold capacity for housing into Kauwhata, particularly for the short term, thereby giving better effect to the MPSUD. For this reason, I am now leaning more towards the submitter's request for a village zone, but note that Mr. Dawson and Mr. Williams also wish to provide further commentary at today's hearing. Also, consistent with my position on Z&Z's submission, it would be helpful for their presentation today to address other matters in the MPSUD concerning well-functioning and integrated urban environments, particularly given that Murali's titles are at the far edge of future-proof syndicative urban limits. My very, my very last discussion is on Kauwhata Land Limited, 24 Wayside Road. Sandra, if you could just...
I'm just sure that's the property there, I believe, where the cursor is.
Yes, that's correct. So in summary, Kauwhata Land Limited considered that today's hearing is the appropriate forum to debate their concern about the proposed provisions on minimum residential lot sizes that affect their land within Kauwhata West Overlay. This same issue was raised by them on the 25th of February 2020 as part of earlier hearing 10 for the residential zone, although they have advised that the panel required them to make a planning and policy argument for the changes sought. While I concur that the overlay is spatially identified on the planning maps, it is clear to me that their concern is the application of the subdivision rule 16.4.3 to their property, which requires new lots to have a minimum net area of 650 and a minimum average net site area of 875 square metres. In contrast, residential lots created outside of any overlay require a minimum area of 450. My section 42 in rebuttal did not make any recommendation on minimum lot sizes. because the earlier hearing 10 addressed subdivision provisions for the residential zone, whereas this hearing 25 addresses the extent of zones. I've also noted that the sets of evidence provided by them for hearing 10 and today's hearing 25 are not materially different. Nevertheless, I consider that the submitter's request does have merit. I noted that the section 42A recommendation in hearing 10 made reference to, and I'm just reading their statement here, they made reference to the rural residential development policies of the Waikato Regional Policy Statement that seek to promote urban form, design and location while maintaining or enhancing landscape views, positive biodiversity outcomes, and to protect significant Indigenous vegetation and significant habitats of Indigenous fauna, and removing the area-specific provisions of the Te Kauwhata West residential area, which aims to retain the Te Kauwhata village character and natural function of water bodies in the Te Kauwhata structure plan. The proposed plan would not be giving effect to the Waikato RPS. I also note that requests from other submitters in hearing 10 to reduce the minimum average net site area from 875 to 700 square metres to facilitate growth were also not supported on the basis that this reduction in area was, in their view, substantial and it may make it difficult to discreetly locate a dwelling and maintain a village character as per the intent of the Te Kauwhata structure plan. With respect, the submitter's property at 24 Wayside Road is zoned residential, not rural residential. The reason for the minimum lot sizes in the operative Te Kauwhata West Living Zone was to complement the size of existing sections in the village to maintain village character. However, that outcome was sought some 12 years ago, well before policy directives from government through the NPSUC and then the NPSUD to address the need for intensification in urban environments, amongst other needs, as one way of solving the country's housing crisis. I consider that it would be unrealistic to expect absolutely no change to the character of urban settlements over the 10-year life of a district plan, and even less so over the next 20 to 30 year timeframes. I just want to mention, I think that there is a link here to policy 6B in the NPSUD, which talks about changing environments. So this is particularly relevant to Te Kauwhata, which is identified as the key growth node on New Zealand's most intensive transport corridor between Auckland and Hamilton. I therefore conclude that there is merit in removing the Te Kauwhata West overlay in order to give effect to the NPSUD and the Waikato RPS. This concludes my opening statement for the Te Kauwhata zoning topic. I look forward to hearing evidence presented by the submitters this morning and welcome any questions that the panel may have. Thank you.
Thank you, Ms. McCartney. We'll see if there are any questions. Can we start with you, please, Ms. Sedgwick?
Thought you'd say that. Ms. McCartney, can I ask about something that was in your 42A report itself, where you talked about the availability of land and made the comment that behind the main road there was 7,000 square metres of available land between the shops and between what is currently the school. Mr. Mitchell, do you want to put a plan up to help? Or Ms. Kelly?
Well, you'll need to tell me where it is.
Sorry.
Can you refer me to the page of the section 42A report? I can put the plan up.
Off the top of my head, no, I can't. Sorry.
Just give me the address that you're speaking about again, and I'll.
Okay, so let's call it 7 Main Road.
No, that doesn't work.
No, don't worry about it. It's
Hey, I've got it up here on our intramap, so I can share it with you. Just
Okay, thank you.
In your evidence, in your report, sorry, Ms. McCartney, you talked about the land that is currently shaded blue, and you referred to that on the right-hand side of the map, and you referred to that as 7,000 metres of land. Yes, thank you. Are you aware that that is an access service lane? It's currently under construction.
Sorry, I can't recall exactly the statement that I made in regards to that property, and I wasn't aware about the access issue. Sorry.
No, okay, you just said there's 7,000 square metres of available land behind the shops, and you're referring to that side, which is a service lane. And the other question relating to the Macali TK land site. In reading the Environment Court report, I understand that both the Travers Road end and the Wayside Road end were a joint application to the Environment Court. That one part has been almost fully developed, the other part on TK lands is waiting. In your opinion, is it a good idea to have a division of typology, if you like, where you would have more intensive land development further out from the centre of town, leading into larger lot sizes and then leading in again back to smaller lot sizes? Because I think I would see that that's what you're proposing.
I'm not sure if I understand the question exactly.
You're proposing smaller land lot sizes on the Te Kauwhata land area.
Right.
Essentially taking off the variation 13 overlay. Okay. I will go back. You've mentioned it even just in this you mentioned it in this in your evidence.
I think this McCartney, what Commissioner Sedgwick is trying to say is that with the Te Kauwhata land limited, the overlay comes off, and therefore you can develop 450 square metres, which is smaller, and that should be more appropriate towards the village, the residential commercial area, rather than out where it is. Is that what you're saying?
Correct, absolutely, twice.
Right.
Very good.
I'm not sure whether I have a really firm opinion on that. I'm just simply saying, in my view, that from a capacity perspective, obviously a change in minimum lot size would give better effect to the MPS in the regional policy statement, and also the proposed plan in terms of capacity, and that it really just comes down to design and achieving integration and looking at those minimum standards through potential resource consent processes.
So the point I'm making, and thank you, Commissioner Kearney, for your assistance, the point that I'm still trying to make is it good planning practice to exit a motorway to suddenly come into small lots, then big lots, then small lots again.
I don't really have a firm view on that.
Okay, no, thank you, that's fine.
I think overall a variety of housing typologies is a good thing.
I was looking at the concept of an inside-out donut. But I've finished, thank you.
Thank you. Ms. Gibb?
No, I'd like to just wait to hear from submitters, thank you.
Thank you. Mr. Marg?
Oh, look, thank you, Ms. McCartney. Your 7-page statement answered all of the questions I had lined up for you. So thank you very, very much.
Ms. Tiaho?
Kia ora. Just a couple of questions. Firstly, do you know what plans there are in place to upgrade the wastewater treatment plant in Te Kauwhata?
Yes, I did mention some of the stages in regards to developing the wastewater system at Te Kauwhata in my section 42. See if I can quickly find, there we are, it's on page 10 of my section.
Yeah, I've just found it too. I'll put it on the screen.
Yes, so just there I've, in paragraph 33 of my section 42. So I've talked about an immediate solution, an interim solution, and an ultimate solution. Does that assist?
Yes, thank
Oh,
you.
sorry, I haven't shared. Sorry, I thought I'd shared the screen. I didn't press the share button. There's those provisions there. Whoops.
I can see a map.
A map, can you?
Yeah, it's the aerial map of Turtle Nut.
That's
That's okay.
That's not from me. I don't know who's sharing that. That's Sandra.
I'll
Kelly.
just go back to the section
It's in
40.
paragraph 33, A, B, and C.
That's correct.
Just a different question then. I'll go back and have a look at that section 42A. Oh, here we go.
There it is there.
Yes, okay, cool. Thank you. I did remember that there was a requirement in the lakeside development for an upgrade. Just in terms of the lakeside development, given that there's already that planned growth there, how much more do you think Te Kauwhata needs to grow in order to satisfy the requirements for growth in Te Kauwhata?
If we look at the analysis that Dr. Davey prepared for all of the settlements, including Te Kauwhata, his analysis, and there's a graph that I've included in my section 42A on page 11. What that indicates is that I think primarily as with Lakeside as being quite a significant contributor, Te Kauwhata gets there in terms of sufficient over the short term, medium term, long term. But in saying that, my understanding from Dr. Davey is that the freeboard is relatively marginal. So the MPSUD is, as you'll be aware, the expectation is not to meet minimum, not to meet absolute minimums. They're not a target. So we do get there in terms of Te Kauwhata, albeit marginally.
Thank you.
Thank you. Mr. Fulton?
Yes, thank you, Mr. McCartney. Just a few, I just looking back through the whole of the Whakawhata area, there was a structure plan done for TK, which was appealed and went to the Environment Court. The Environment Court, and this is my understanding of this, the Environment Court found fairly much in favour of the structure plan with some minor changes. But where we're coming to now is you're saying that you think that you know, the lot size of 650 square metres and the 875 square metres are now outdated. You also go on to make reference to you know, the fact that the National Policy Statement on urban design, development and so on is now starting to trump those things that were done because that's the requirement now. So in effect, this would be actually changing the structure plan and applying the new standards without any consideration to what the original structure plan was. And by the reading of it, TK had a village view much different than most other urban towns might have had, to want to keep their nature of their village, which was a pretty open spaced village. Have I got that right? That, you know, you're believing now that it just needs to be modernised and shrunk down to suit the NPSUD and other new standards that have come in?
I don't for a minute think that the NPSUD trumps everything, and I guess this is the tricky task of trying to provide capacity within an urban settlement, but also at the same time striking some balance with amenity issues. But you know, I had mentioned policy 6B in the NPSUD 6B, which talks about change, and that's not an adverse effect in itself. So no, I'm not saying that the NPSUD is absolutely the final word, but certainly it does direct council to think more than previously about providing greater intensities and looking at towards building up as well. But yeah, I mean the NPSUD, and I've just finished doing a major exercise on that document a little while ago. That document contains a number of what's called qualifying matters. So, for example, you may have an historic building, for example, in the middle of a town, and those sorts of things need to be taken into account as well. So it's a balancing exercise, in my view.
Okay, thank you. The other, you've made quite a lot of reference to the Environment Court decision and referred to that through your 42A report. So you have given quite a lot of weight to it. I suppose it'll be up to us to decide how much of that we consider weight we give to it. But you've taken a lot of comment from that. So I take it you still believe that the Environment Court decision is still quite a prominent document in the scale of this whole refurbishment of TK?
I don't think it's the last word. My view is that much of the commentary that the court made in respect to the directions that Te Kauwhata should grow, I believe are still relevant. So the court made some comment about the Whangarino Lake Waikari environments, for example, and also I think there was some mention about the existing quarry that's down towards the end of Swan Road as well. So those locations act as constraints to growth. So in my view, that those comments are still relevant. And of course, the court was looking at that time at the existing character of Te Kauwhata as well, as it was 99 years ago. So yeah, my only comment is in regards to minimum lot size, and obviously the Environment Court was made well before the NPSUD-C and the NPSUD that we have at the moment.
Okay, thank you very much. Thank you.
Thank you. Mr. Marg, I don't recall if I asked you or not.
No, I had no questions. Thank you.
Thank you. Mr. Kearney?
Yes, just a few questions. I think it's the Clyde Juices matter dealing with the reserve issue. Have I got the submitter right there?
Clyde Juice Limited, yes, they are the owner of that property.
That reserve is owned by, as I understand it, Clyde Juices. It's never been taken by council.
That's correct.
And yet you still say it should remain a reserve.
No change from the operative plan. Yes.
You don't think there's a question of equity here, that that unless it's been offered by Clyde Juices as a reserve or as a quid pro quo for something different, you don't normally put a reserve over private land unless you take it, do you?
Yeah, I think I absolutely understand the point that you were making.
Is that something you want to reflect on?
I would like to be given an opportunity to reflect on that. I guess I swayed away from that question mark a little because I wasn't sure about the scope of that submission, because they'd only touched on the extent of the reserve, they hadn't questioned the taking of the reserve full stop. But I'm very happy to have a look at that.
All right, okay. Just the Te Kauwhata land issue, Mr. Macaulay and yourself, there's no issue there now. Have I got that right?
That's right. Yes.
Right. Okay. With the Muir property, could you just put up the map again of that area? Or someone?
Yeah, give me 2 seconds. I'll just get it back again. This is just the zoning as a whole, but
yeah.
Sorry.
Yeah. Around that is around the Muir property is zoned country living, all that area. Is that right?
That's right. Yes, everything that is coloured green, olive green, is country living.
So if you were to accept the submission from Muir that should go to village zone, it would be village zone within a larger country living zone area, wouldn't it?
It would be at the far edge. It wouldn't be completely surrounded because we're talking about those two titles at the end of Vineyard Road. Oh, sorry, there's one title to the north, and there are two adjoining titles to the south, with the railway running along the eastern side of those.
And okay, it would almost become a spot zone, wouldn't it, for the village zone and its location there?
That is something that I did touch on in my section 42. I had raised that issue. New Elite did respond to say in their view that they didn't consider that would constitute a spot zone because we're talking, in their view, they said that a spot zone would normally apply to a single property. Whereas here we are talking about two titles in a total area of some 22 hectares. Unfortunately, we don't have a definition of spot zone, but I take your point. I mean, normally a spot zone, I guess, would apply to a single property, but I'm happy to move a little bit on that.
All right. How far away from the village, the town village, is that property?
There's the scale down there, Mr. Cooney.
Oh, okay. Yeah.
Yeah, I haven't done that calculation. Are we? Is your question as the crow flies, or are we talking about driving down the road?
Driving down the road.
One, two, three, 4, 5. I'd say about 6 kilometres by road to the railway line, give or take.
Okay. Thanks.
Does that sound about right? 1.
Yes, it does.
2, 3, 4, 5. Yeah, I reckon 6, give or take.
Thanks for that. Just generally, as a general observation, isn't it better to retrofit residential into country living rather than a village zone?
My feeling is that we have country living zones and we have country living zones. I mean, certainly, in my view, that the difficulty is when a lot of the country living zone lots are already developed. So a number of those you can observe along Vineyard Road. A number of those countryside living zone lots are already at the minimum lot size, and they already contain quite substantial dwellings that have been placed central to those properties. Were you talking about a blank canvas, so to speak? It is much easier to retrofit.
Even though the lot sizes would be, they'd be smaller, they'd be 3,000 or even 2,500. Are you saying that those lot sizes are easier to retrofit into residential later in time?
I think a lot depends on whether they're developed or not. That's the tricky thing here. And I think it would be very useful to hear Newley's view on those matters later this morning.
All right. Just generally, what is the availability of lifestyle, inverted commas, blocks in around Te Kauwhata? What's the supply like?
Are you talking about lifestyle lots in the rural zone as well?
Yes.
Not sure if I can answer that, sorry, but maybe that's something that I can investigate and come back to you.
Well, one submitter, I think it might have been Mr. Williams, might have said there's very little available inverted commas, lifestyle blocks available around Te Kauwhata. There's only about another 3 years supply or something. Did you want to comment on that?
I think that's perhaps something that Mr. Williamson or Mr. Dawson can respond to a little bit later, but I think that comment was made in respect to the existing country living zone within Te Kauwhata.
I suppose the point I'm trying to make here is that if there is a shortage of these lifestyle blocks, then why change what's there now into something different? Do you want to comment on that?
Yes. Yeah, I'd like to have a bit more of a ponder on that one, please, if I may.
All right. Okay. So, thanks, Mr. Chair. Thank you.
Thank you. My questions have been answered other than one. I just want to come back to Waikato 2070 for a moment. And this is the Te Kauwhata section. Can you see that? That's taken from section 42A report.
Yes.
Can you just explain to me this area here, the sort of Travers Road, Vineyard Road area, the Te Kauwhata West, that's all shown in Waikato 2070 as being developed in the 1 to 3 year time frame. Can you just explain, and it may be in the key above it, but what this denotes here? I see that further down there's a different sort of house, and there's townhouses here. What does that connote into this thing in the circle here?
Yes, there is a.
Is there a key at the top?
Yes, standalone dwellings.
Oh no, sorry, it's lifestyle lots, isn't it? It is life. I was going to ask because I was looking at it and saying, well, it looks like it's being intensively residentially developed in 2070, but it's actually not saying that. It's actually saying, as per this one here, that they are village/country living. So I just wanted to understand that better, and I've answered my own question. I do understand it a bit more clearly now. I thought all these houses meant the same thing, but they don't. These descriptors here. So Waikato 2070 identifies this whole area as village and/or country living zone, doesn't it?
Yes, that's correct.
Yeah, okay. No, that's helpful. Thank you. Thank you very much, Ms. McCartney. And perhaps if you can ponder on those questions that you were going to ponder on, and we'll hear back from you either at the end of the hearing or happy for it to be in your written reply that we can expect in due course. So thank you very much.
Thank you.
Thank you.
That brings us to Mr. Searle. Is Mr. Searle present? He wasn't earlier. Doesn't look like it. What about Ms. Byers? No, well, we'll keep moving. Mr. Gray for Hugh Green Limited, please.
Hello, can you hear me well?
Yes, thank you. Yep, we can hear you fine.
I wish to give apologies for Mr. Ian Thompson, who's unable to attend. He was the economics expert.
Yep, thank you.
So Hugh Green's submission related to their land on Salyard Road, behind the existing town centre buildings on Main Road. Under the operative plan, it was part of the mixed use policy area and in a business zone. The land in the operative structure plan for the area showed it as part of the commercial precinct. Other land nearby was included as part of open space and residential precincts, also in the same operative zoning. The proposed zone has opted to zone the whole area, including, or basically an area of 12 hectares, including the main road shops and around 9 hectares of either vacant or historic rural activities, all of that area as business town centre zone. The submission of Hugh Green was for that 9 hectares of land, including their 1.5 hectares, to be changed to the business zone. And the primary reason for this was the concerns about the level of restrictions in the business town centre zone, particularly the maximum GFA cap and some of the provisions around the retain the existing character, which to me didn't make sense to incorporate on land that is essentially vacant, undeveloped. It made most sense to retain it for the existing main road. And I comment that Ms. McCarthy, after rebuttal evidence, has now agreed with the position of the submission. So I guess from there, I'm happy to take questions.
No, thank you very much, Mr. Gray. I think that is pretty clear. We'll see if there are any questions for you. Ms. Gibb?
No, I'm happy with the response and the rebuttal evidence, and looks like you're in agreement now. Thank you.
Mr. Marg?
No questions. Happy to see that both parties have come to an agreement there. Thank you.
Ms. Sedgwick?
No questions or comments. Thank you.
Ms. Tiaho?
Nothing from me. Thank you.
Mr. Cooney?
Thank you.
And I don't have any questions either. Thank you very much.
Thank you very much.
Thanks, Mr. Gray. That brings us to you, please, Ms. Sunday. And you want to talk to us about Travers Road.
Oh, yes. Okay. I had two submissions, and one I was supporting, and then it was Travers Road. So do I just talk about the one?
Well, you can talk about both of them in the order that you wish.
Okay. Well, the first one is Travers Road, 102 Travers Road. We're supporting that stays as country living, and you've got my submission there about that, just to do with the the big concern for us is the water and that sits there. But no, you've got that. But the second one, the main one I want to talk about, is we're opposing our land at 126 Travers Road. I did have there was a plan that went in with that, but I don't know whether, oh yes, that's the one there. Our 126 Travers Road is the one marked in red there. Just that we want it, at the moment it's zoned residential, and we'd like it changed back to country living. And the main reason for that one is that to do with the flooding, and as you can see, we have a protected overlay over our land, and that goes down through right through the centre of our land, and we find that we actually can't subdivide that land because of that. And in addition to that, the pointing that most of the water comes from the Waikere Estate subdivision, comes down through our land and collects through the land and goes down and flows into the Whangarino wetlands. And we're just feeling that because we can't subdivide, and also too, the land behind us at 128 is basically the same with the volume of water that comes through at different times. We've lived there 28 years and we've seen quite a bit over the years, and we just feel that the land beside us and across the stream there is country living, and just making it in par with keeping it in line with that, as we feel that there's a lot more subdivision around and further in town, and trying to keep Kauwhata as a village atmosphere. Yes, that's about it really. That's just what we're feeling now. Our strong point is basically that we can't, because of the protective overlay over our land, that we can't subdivide.
All right, no, that's clear, I think. Thank you. Let's see if there's any questions for you, Ms. Sunday. Can we start with you, Mr. Mark, please?
Yeah, just one question, Ms. Sunday. What's the total hectares of your property again, please?
1,200.
1,200 square meters. Thank you.
Yes, square meters. Sorry, yes, 3 hectares.
Thank you very much. That's all.
Thank you. Ms. Tiaho?
No, I'm clear. Thank you.
Ms. Gibb?
No, I am reasonably clear on that. It's just I can see the overlay there, and I can see where your houses are, and is that obviously a higher point on the land?
Yes.
Okay, so I understand your submission. Thank you.
Thank you. Ms. Sedgwick?
Nothing from me, thank you.
Mr. Fulton?
Just saying, you say that you can't build there because it's too low, but with engineering effects, you can actually, you would be able to build, wouldn't you, to a standard that would be above the floodplain and all those sort of things?
At this up by the house we can, and there is the same one over there up to the back of the place. There's a bit of land there. Actually, all the water that flows down through the Waikiri estate actually flows through there, and there is actually a drain that goes down the centre of our place. It's actually quite low, and when it does flood, it comes right back up through that drain. And as much as you say this there is engineering, it would have to basically, you'd have to look at changing the whole concept of the whole land. You'd have to take the grapes out and everything to be able to make, which would be something further down the line.
Okay, I understand that. Okay, thank you.
Thank you. Mr. Cooney?
What are you growing there at the moment? Is that
table grapes, and they've been there for over 28 years. It's Niagara, the green grapes, and Albany Surprise, which are the big black ones. And there's only 3. There used to be 44 vineyards in Kauwhata. We're down to 3 now.
okay? Yes, no, you're very clear, so thank you.
And I don't have any questions. Thanks, Ms. Sunday. It is pretty clear. We can understand what it is you're seeking and why. So thank you for that.
Thank you.
Thank you. Let me see. We're a little bit ahead of schedule. Mr. Dawson, there he is. Mr. Dawson, are you ready to begin your presentation to us, please? It would seem not. Someone just joining with a partner in the background that looks in a state of partial undress. I thought I'd just warn you. All right, so we're ahead of schedule. Are you there, Mr. Dawson?
Mr. Chair, that may be Michelle. Oh, she's gone again. That
might have been Ms. Byers, I have a feeling.
Sorry, she's gone again.
No, she's gone. Oh, I think all we can realistically. There's Mr. Dawson. There he is. Are you ready to begin your presentation, Mr. Dawson?
I'm just waiting for Mr. Williamson, who'll be with me. Can we perhaps have 10 minutes?
Yeah, well, we'll take our morning adjournment now, and we'll resume again at 25 to 11. Thank you.
Sure, you will be ready.
Thank you. And if people just turn their videos and sound off as opposed to leaving the meeting completely, please. Question for you. We could turn the recording off, please. We haven't started yet. Limited.
Good morning, Sue. Good morning, panel members. I'm sitting here today in Whangarei, and I've got Mr. Williamson sitting next to me. Just a point of clarity. The original submitter here was Vineyard Road Properties, a client of mine. They've now been superseded by Muirlee Limited. That's simply a commercial arrangement. The submission relates only to the Muirlee Road property, which is 22 hectares comprised, and I think 3 titles. Sir, I've heard the conversations this morning and the questions asked. I've also listened to Ms. McCartney's explanations and responses. It seems to me that there are 2 issues here which are articulated to some extent in our evidence and my legal submissions. The first issue is, what is an efficient use of this property, an efficiency in zoning, number 1, and number 2, what is the necessity brought about by growth and demand pressures. Just to comment briefly on those. In terms of efficiency, we say that the countryside living zone with an originally notified minimum site size of 3,000 square metres is not an efficient use of the site. And that's the reason why the original submission focused on efficiency and requested a smaller site size of 2,000 squares and or a village zoning. And I note that there are numerous submissions that you've heard and you've yet to decide really in respect of both zones and saying, hey, the minimum site sizes need to be tweaked. So our view is that there needs to be an efficiency here. Around about 2,000 square metres minimum site size would be appropriate, but it may well be less than that. And that may well be because of the decisions you make in terms of the village zone. So that's the first point. The second point is, I noticed reference this morning to the growth strategy and the bubble plan around Te Kauwhata. Mr. Williamson can speak on this, but he tells me that that growth strategy does not draw a distinction between countryside living zone and village zone. What it does is it talks about lifestyle, quote unquote, properties. So that could be a village zone, that could be 2,000 squares, it could be 3,000, 4,000 squares. And we say by 2023 in TK, all of that land's used up. There were just a couple of other questions I heard this morning too. One was, would this result in a spot zoning? Well, it's covered in Ms. McCartney's report, of course, and our evidence quite well, but the essential point here is that at 22 hectares, this is a large property, and a rough reckoning suggests that it's the largest in the Vineyard Road, Te Kauwhata area, and that those adjoining it more in the order of sort of half a hectare to a hectare, and they're already developed. So here's an opportunity to look at, what's considered, I think, a large property in an appropriate zoning. I'd like to just touch briefly on the question of scope. And the reason I raised it in my submissions to you was because Ms. McCartney canvassed it in her 42A report. And it's somewhat unfortunate, I think, that we've had countryside living, the reporting planner saying no, don't like anything less than that, to saying, well, it should be a residential at 450 square metres, to saying this morning, well, I'm actually supporting or thinking about supporting a village zone brackets, whatever that density might be. And so in terms of scope, this is where it becomes an issue, I think, is original submission said village. I think what that means is village, whatever the rules are that the panel may decide those should be, and particularly the minimum lot size, number one. Number two, it said 2,000 square metres and or an efficient use of land. So I think there's some flexibility in that number. And number three, it said it should apply to all of this land identified in Vineyard Road. And that could have resulted in something in the order of 200 to 300 sites. Now it says, no, the scope's been reduced to just this property. So in terms of what might have been expected, I think there's some flexibility there. Summary point from us, we're saying a village zone, whatever that is, it's 2,000 square metres or less in our view, and that would be an efficient use of the site. Those are the four corners around it. I'm going to ask Mr. Williamson to perhaps answer the questions that you had this morning, unless there's anything you want to ask me right now.
Let's hear from Mr. Williamson, and then you're doing this as a bit of a tag team by the sound of things, so I think we'll do the same. We'll hear from you both, and then we'll ask questions and you can allocate the answers as you see fit. I think that's probably the most efficient way.
Thank you.
Thank you, Mr. Williamson.
Thank you. So just I could probably go through, I think there was a couple of questions that were out this morning around start with the sort of whether it's a spot zone or the geographic location of the Vineyard Road property relative to the Kauwhata town centre. Te Kauwhata has got, as you pointed out, Mr. Chair, in the growth strategy, it's got a physical sort of extent, so it's a sort of metropolitan limit, so to speak. This is on the edge of that, and as I've described in my evidence, Te Kauwhata is largely sort of geographically constrained in many respects by topography and the lake and the motorways and things so on. So unlike a village where the future could keep on growing and expanding and become a new sort of town or city, this is one where we know what the physical extent is going to be. We know where the town core centre is going to be. So the sensible thing to do in terms of planning forward is to allow for further intensification over time. And to do that, in my view, you want to leave the physical perimeter of the growth area as its final form of development, which sort of sets that boundary, almost like a sort of a mushroom ring effect. It gives you flexibility when you're developing back inwards towards the town centre to actually change those zonings over time as well. So in other words, in this particular case, I've pointed out that there's a future shared path along the side of the railway, which provides a linkage directly to the village zone that we're proposing at Vineyard Road, which is closer to the town centre than some of the lakefront property in terms of geographic extent. But if you'll see the side of the countryside living zone as it is, all the ones fronting the railway along that corridor are all the larger ones. In my mind, there's plenty of scope to be able to develop those to a village zone, and in fact you'd need to develop into village zone or higher densities to probably fund the infrastructure that's indicated within that sort of growth strategy. So in terms of spot zone, I don't think it is. I think it's just the alternative of starting at the known extent and then working our way backwards, which gives some adaptability and flexibility over time. In terms of there was a related question which I can't recall. That was largely it, I think. But yeah, I'll leave it at that. That was just the one for that sort of question. So you'll have to sort of prompt me on anything else as they come to mind with the other commissioners that sort of came up. But basically, we think that the village zone does provide for a lot more sort of efficiency, and I won't sort of bore you with going through all my evidence again, but if you look at my sort of principal statement of evidence and my replies, I have done quite a bit of a spatial analysis and given some illustrations about what the typical development patterns in those locations are, around 5,000 and 2,000, and the ability to subdivide or further intensify those. But I think the question that you put to Ms. McCartney that she didn't answer in terms of is it easier to intensify 5,000 than it is 3,000? In my view, it's not. 5,000 square metre sites or half hectare, once they've been capitalised and built upon, they're a heck of a lot more expensive to aggregate and redevelop than something smaller. I mean, it's just a function of land value, effectively. So those are sort of the two that sort of jumped out from this morning's session, but as I say, I'm happy to elaborate on anything that you've seen in my evidence.
All right, thanks, Mr. Williamson. Let's see how we go with questions for the two of you. Can we start this time with you, Mr. Marg, please?
No, thank you, gentlemen. I think you've made it abundantly clear to me, so I have no questions.
Thank you. Ms. Te Aho.
No questions from me, thank you.
Ms. Sedgwick?
Yes, I do have a couple of questions. Thank you. You talk about in your point 48 of your evidence of the 26th of February, you talk about a multimodal corridor, and then I'm looking at point 61 where you have a map of the network plan. This is of your evidence of February. And I wonder if I might suggest or seek your comments on whether that plan is actually still up to date and in fact even believable. I note point 8, town bypass, was mentioned in the section 42A as having been removed, that designation, and in fact land has been sold off that was taken under notice of requirement. Point 4, again, for example, does not have through site linkages into the new subdivisions because they don't align. And I'm wondering what your comment is on the link beside the rail line, because I cannot find it mentioned in the long-term plan. I can't find it mentioned in any of the infrastructure documents or of any of the council plans. So I wonder if you could just elaborate on that for me, given that we're looking at something that is relatively elderly here.
I wonder if perhaps it would help if we could perhaps get that map brought up on the screen, please.
Yes, it would. It's point, if you can, it's point 61 of Mr. Williams' evidence on the 26th of February.
Give me a moment. I had his summary statement open. Just a minute. What paragraph was that? Sorry?
61.
61.
Oh, 61. Sorry, I was at 64. Here we go.
Yeah. So you got it in front of you. Yeah, you can see it there. So that as it says underneath, I think that's figure 8 of my evidence. That's the network plan for Te Kauwhata from Future Proof 2017. Now, obviously, the council is going through its Future Proof, update refresh at the moment. But given that the Future Proof strategy is looking up to sort of 2070, the long-term council. Sorry, there's a lot of noises.
All right, sorry, folks. There's someone's having something happening in the background. If you're not speaking, if you could please turn your microphone off. Thanks, Mr. Williamson.
Yeah. So sorry. So the Future the future-proof, it's got a planning horizon of sort of 30 to 50 years. So you're looking at the 2070 sort of planning horizon. So not everything in that is going to be in a long-term council plan or even an asset management plan, which are basically got a 10-year horizon. We're talking different sort of time horizons. So it won't be budgeted for or anything in the council's infrastructure at the moment, unless it's something with urgent priority. I guess my point being in the relevance of that is this, that network plan is, I guess, trying to do what the new RMA reforms are trying to do, which is to try and provide some sort of long-term spatial planning, which enables, funding and planning and asset design to take place, knowing what the future extent of the village is going to be. And so it's indicating that that corridor, and that given that the low level of density that currently exists there, if you're going to put a new multimodal corridor, that's where you put it. There may well be train stations or anything there. Who knows what's happening with, electric rail to Hamilton as a commuter service. So if we're talking 30, 50 years from now, then it absolutely is feasible and viable to have an access corridor there. That's maybe well be a commuter stop for trains in our village.
Thank you. So can I just ask you a plan B? Should you not have that multi-mode corridor, you would be exiting up Vineyard Road, presumably. So you'd be putting anywhere between 40 and 391 vehicles, double that because they have to come home, a day up through a country living zone. Is that a good move from your perspective?
Look, I don't see any particular problem with it. What we're talking about is the ultimate future of Te Kauwhata, right? It's not going to change. Well, Te Kauwhata is not going to stay the same as it is now. And looking at all of the extent of the zoning in the residential area everywhere, right? So certainly Vineyard Road is a asset at the moment in its carriageway. There's nothing wrong with it to be able to handle that volume of traffic. And in my view, I'm not a transport planner, but it's it's not an unsealed minor road.
Can I just say on that to help? I'm aware from my client's own previous development in the last several years, as I understand it, there was a reasonable amount of upgrading required to Vineyard Road, including widening of it at that time. So that's just something to bear in mind in terms of traffic safety, which is, I imagine, what you'd be most concerned about.
That was where I was looking at. And just finally, Mr. Williamson, you talked about the Flatbush transition zone. And thank you, I found that quite interesting. Would you not then draw the conclusion from that that you have a natural transition from the urban area, residential area of Te Kauwhata to the country living area out to Vineyard Road, and you have farms further on, but you want to put a spot zone in the middle? I'm not sure how that works with your argument that it's not a spot zone.
Well, spot zoning, traditionally spot zoning has been a individual property that might want to have zone as a daycare or a shop or something, right? That's within one particular discrete site. The area of land that we're talking about is larger than many of the existing settlements that you've got in your district. It's not a spot zone in itself. What I've talked about in terms of the countryside transition, I mean, and I'll digress a little bit out of scope, but what I've done in elsewhere, so at Whangarei District Council, we had an urban transition environment, and we've provided for rural apartments with spaces in between, right? So there's opportunities to be able to rezone it to residential in a way that hasn't fragmented it. There's a whole lot of options I don't think the Waikato District Council has considered as part of their planning framework at all. That they've opportunities lost. But no, I don't see it's a spot zone. As I said just before, I would say that that's the final extent of village zone in Vineyard Road, and the area between this client's site and the town centre has got 50 years of development happening. And if it was allowed to be full and final form of development at 2,000 square metres or so, it's not an efficient use. It's going to be extremely sprawling. You do need to provide for opportunities for intensification to make use of the reticulated infrastructure you've got in this location. So no, I don't see it as a spot zone at all. It's just a different sequencing. What you're talking about is sequencing and timing. This will be the stage one of the 50-year future of Te Kauwhata. Bearing in mind 50 years time, it may not be car dependent. We may well have e-bikes and have access cycleways. It doesn't mean to say you need to have, 3-4 lane roadways. And I dare to say that there won't be in 50 years time.
Lovely, thank you very much. I have no more questions.
Thank you. Mr. Fulton?
Yes, thank you. It appears to me if that land was put into a village zone, it appears as if the population and all the new growth in Te Kauwhata is a long way from the centre of town, and we worked out 6 kilometres thereabouts by road. It appears to me that the rural lifestyles have been taken up and all the area has been taken up and the population has grown in that area, but the urbanisation of TK hasn't grown very much in the last 5 years. Would that be fair enough? It's been the country living lifestyle or the rural lifestyles that have been requiring to be taken up. They've taken up most of the growth.
You mean in terms of the growth of the village in the commercial area itself?
Yeah, well, the growth of the village as such. I mean, the growth has actually taken place right on the peripheries, hasn't it? On the country living zones, on Vineyard Road, and so on.
Well, you'll find. I mean, every small town in New Zealand, that is what happens, right? Because people live in places like this because either they want the lifestyle or the affordability, generally. And seldom do people want, residential suburban amenity, in a little town when, they can't afford to have one in Auckland. They come out to here. There's less of an appeal if you've got a residential section with, a handful of shops in the main street. There's generally not as much demand for that type of thing, unless you see what's happening in Pocono, for example. What happens is you have an opportunity for people to, build their nice big dream home with double bay garage and so on. And then what happens is once the population catchment is large enough, you get your new Robert Harris moving in, or your Foursquare upgrades to a smaller sort of supermarket. That's what happens. It's not the other way around. The commercial area doesn't lead development. In my experience for the last sort of quarter century, this is how it works.
Okay, thank you.
Thank you. Ms. Gibb?
Yes, I think most of my concerns have been spoken about regarding the access to the town. And I had the question mark over this walkway that I'd not really heard much about within council. But having said that, you've answered all that. And I just want to clarify the scope issue, because there was discussion about should it be residential at one point. And you're saying, I think that because in your submission you talked about 2,000 squares or less and efficient use of land, are you saying that that means that there is scope for smaller size lots?
No, I mean, I have to say it was a bit of a surprise to us when we got Ms. McCartney's second report saying it should be residential at 450 squares. It would have been nice to have heard that a bit sooner. But I think in terms of scope, if we're looking purely at section size, our submission says 2,000 squares. So, and it concerns, and it can, contest the issue of efficiency. So I think if we pick the number and we said, it's between 1,500 and 2,000 squares, I think that would be within the scope of our submission. That's number one. But number two, we've asked for a village zone, and you guys have got dozens of submitters who are saying in the village zone, the site size should be a lot less than what was notified. And so if you decided a village zoning here and the site size was lowered in that zone overall, then that too would be within scope. So it's kind of what, one or the other, I think gives you quite a degree of scope. And it sounds to me like, in terms of the officer's recommendation, in our view, it's kind of landing on a village zone with 2,000 or less.
So I might be wrong here, but I thought 2,500 was the minimum you could have for wastewater, for waste, e.g. sewage, etc.
Yeah, so
take me on that.
So my understanding of it, and somebody can correct me, but my understanding of it is 2,500 squares came out of hearing topic 6, and that was the council officer's recommendation. But you've got numerous submitters, ourselves included, who are saying no, 2,000 or even some people are saying less is more than adequate for on-site servicing. So, and those are decisions you get to make, right? But so all I'm saying to you in simple terms is, I think in terms of scope, zone to one side, it's 2,000 squares, or perhaps a little bit less here.
Okay, thank you.
That's helpful.
Thank you. Mr. Cooney?
Yes, either one of you, but why is converting country living zone to village zone, and in this case it'll be 5,000 down to, you're saying 2,000 or less, why is that a more efficient use of land?
I'll ask Nick to answer that from his surveying background, sir.
So I think in my evidence, and may have been my first sort of reply evidence, I've done there's some GIS maps that I've done which shows what the typical land occupation and development pattern is for 5,000 square metre sites. So I've taken some aerial photography from some of the zones that are already subdivided down to 5,000. And if you look at where people place their dwellings and how they use the land, they do it for privacy. They're all equidistant, right? They'll plonk a significant size, over 250 square metre up to 500 square metre footprints in the middle of the properties. Now, I was in all of the time I was working at Manukau City in the sort of future urban areas from what had been horticultural blocks or lifestyle blocks, trying to upzone those to residential is nigh on impossible, just because how the land title configuration relies on people getting together and developing things, more comprehensively. If you're smaller, you don't have all that wasted curtilage. That's the main difference, right? A 5,000 square metre property is way too big to actively mow, unless you've got a pony or something. They just tend to be left and not used for anything. Certainly nothing productive, and certainly nothing from they're just a big park land around them. It's extremely inefficient. If you double that density down to sort of 2,000 square metres, usually your coverage rules then make the buildings smaller. The properties are cheaper than they are because you're paying half as much square metre land area. And what you're then doing is effectively allowing for, probably at best, some sort of discrete infill type development. And you might get it down to 1,000 square metres or less. I mean, it's not ideal. That's why I'm saying 2,000 square metres is more a final form of development. If you wanted to future-proof it and be able to make it into a living zone at some future stage, then you're really needing to go down smaller again, the 1,000 sort of square metre sizes. And I give an example, I think in one of my rebuttal evidence of looking at Raglan, right? That's reticulated 800 square metre sites. You're into residential intensification at that point.
I'm sort of struggling that the issues you describe for country living, where you plonk a big house in the middle, and it forecloses on any other options for closer development. I sort of struggle as to why the same impediment doesn't apply to the 2000 village zone issue too. You get people just putting up houses in the middle of the block, wouldn't you? And
well, that's what I said.
You're just transferring the issue from one zone to another, aren't you?
Well, no. What where the council needs to have better sophistication and is missed an opportunity in my view, is it comes down to your typology, right, and your design guidelines for your subdivision. And as I say, I mean, I've created a zone when I was at Whangarei District Council. We called it the urban transition environment. We had a density of the same as this, 1,000 to 2,500 density. No, it was actually 1,000 to 5,000 density. It was the same as countryside living. But we had a maximum lot size of 2,000 and no minimum. And basically what we were encouraging in that zone was rural apartments. Same as what you get at those country club resorts and things all over the place, right? So if you were to have a rural apartment zone, you can have the overall household density that you can plan for, and that's what we did in Whangarei. So we called it an urban transition because A, it was on the perimeter and peri-urban areas, but B, you could transition it from countryside living into full residential by just subdividing the area between the apartments, and you've got a full urban zone. So it's just there's perhaps a bit of a lack of imagination from the planning fraternity generally about how to design rural growth, to be quite blunt.
Okay. Yeah. I've often been told I haven't got an imagination. So.
Well, I wasn't applying myself.
Okay. Thanks for that. I think I understand where you're going with that. But just on the wastewater here to the Muralea block, when's it? How accessible is a wastewater connection here?
Reticulated. It would need to be extended. And that's set out in the framework report. In the framework report, it says that there's no physical limitation, so there's no deal breakers. It just becomes a factor of dollars and cents at that point.
Do you know whether it's planned or anything into the future?
Oh, look, I'm not sure that it is. I mean, what's happened again? The future-proof strategy is being developed, as we speak, and the post-COVID world, and all things are going on at the moment around that sort of space. I mean, it's a moving target, I think, at this point. But again, I guess what I'm sort of saying is those infrastructure in planning and providing for it, I mean, that actually helps. And if more intensification was provided for in Kauwhata, or even signalled, it doesn't need to be in the district plan because it's only 10 years, and it may well be that the infrastructure, rollout timeframe is longer than that. That's what your future-proof, cannot be identifying.
All right. Okay. Thanks to both of you. Thank you.
Just one from me, and following on from that about wastewater servicing in particular. Can either of you help in giving me an update on where the consenting aspect of the new Kauwhata wastewater treatment plant is? Ms. McCartney talked about the 3 stages of proposed upgrades. Do either of you know just where that process is at?
I'm afraid I don't know either.
All right, no, that's Ms. McCartney. Can you elaborate or provide some illumination on that one, please?
Mr. Chair, can I have one further question?
Yeah, in a minute.
In a minute, yeah.
Yep. Are you there, Ms. McCartney?
Yes, I've just joined you. Other than what I have written in my section 42, I can't add anything extra.
All
Sorry.
right, no, that's okay. Perhaps if you could add that to your list of things that you'll further consider and come back to us on it, I think we'd appreciate just a heads up on. I mean, it's one thing to say there's going to be a major upgrade in 2024, I think it was. That's not all that far out. And I know in the past, those consents have not been straightforward, or those consent applications. So it would be just helpful to get a heads up on where things are at, please.
No problem, can do that.
Thank you. Ms. Cedric?
You just reminded me with your question there on wastewater. I'm thinking that you may be quite, this property may be quite a distance from the existing wastewater reticulation, in as far as it goes to halfway down Travers Road to the estate that has been built there. So it's quite a, I just wondered what your comments might be. It's quite a long expectation to take it through all the country living sites and then onto your one.
Yeah. So well, I mean, I can sort of, I guess it'll perhaps provide a sort of augmented answer to your question about sort of site sizes and so on. I mean, I've been involved with developments of this scale where there have been some limitations in the availability of waste treatment systems. And going back to your sort of your thoughts that there was a lot size requirement for on-site servicing, that's to fit, generally that's your disposal field for your tertiary treatment of a 3-stage, right? What would typically happen, and again, this is what we've done in the Whangarei district, is you have your primary and secondary treatment, like your tanks can fit on your property, and then they are all piped to a combined disposal field or a wetland or something. In this particular case is quite good with that, because there is actually you know, the bottom of the kitchen up to there. So you could have a combined disposal field. So you could have 800 square metre sites, in my view. Reticulate doesn't say it has to be publicly reticulated, but you've got to have a reticulated sites. You could do 800 square metres, put your solid waste treatment and, you know, aerobic sort of tanks there, collect all of the liquid waste from all of them and deal with it together. Now, ultimately, I mean, that may well be a temporary fix until such time as the reticulation is made available and provision made, you know, through development contribution or whatever, to actually hook it up. And that's what we did in Flatbush, where actually people wanted to go ahead of zone, they paid for on-site treatment, and when the reticulator was, whether they had to connect to it was a condition on the titles. So there's examples of how that can be done, and it may well be that it's put into a tank within the property and one pipe and it's pumped wherever. I mean, it's an engineering solution.
Excellent, thank you.
All right, thank you, gentlemen. Thank you both. We have no further questions of you.
Thank you.
Thank you.
How are you liking these Zoom hearings, Mr. Dawson? No trip from Whangarei down to Ngaruawahia today? That must have been good.
I'm getting used to them, I have to say. I'm not quite a convert just yet.
Wrong answer.
Getting there. They're good.
Very good. Thank you.
Thank you.
Thank you.
Ms. Byers, sorry, we indicated over the break that you could go after morning tea, but we lost you for a moment and we weren't quite sure what was going on. So we'll hear from you now. Thank you.
I wasn't quite sure what was going on either, but yeah, Zoom is new to me as well. Now,
if you could just turn your video on, please.
Oh, yes. If I have to, yes. Right.
Very good. Thank you.
My submission was regarding Travis Road.
Yes.
And my biggest concern, of course, is our water problem and our, oh, how do I put it? Our creek down the bottom, which quite regularly overflows, runs to the Whangamarino wetlands. Now, I think the proposed, we have 5 sections in an area at the moment that is, I think, proposed for 24 or something like that. Now, my problem is the water problem. We're above the floodplain down there. Oh, below the floodplain down there, sorry. Yeah, so I don't know what else I need to say.
We understand that, and I think, and the point that you're making is pretty similar to the one that Ms. Sunday made earlier. So we've heard from her. I don't know if you were present when she presented to us, but it would seem to me, at least on its face, that your concerns and hers are similar, if not the same. Would that be fair?
We're on opposite sides of that property, so
Yes, yeah, indeed.
yeah.
All right, well, I don't think you need to tell us any more unless there's anything else you want to tell us. So let's just see if there's any questions of clarification. I suspect there aren't, given what you've said and what Ms. Sunday said, but let's just see. Can we start with you, please, Ms. Gibb?
Yes, I just wanted to work out on that map where your house was, because that map didn't show me little square boxes where your house might be. Can you explain where your house is?
We haven't got one. We're in the process of that, but hang on a moment. I will just, where are we? Gosh, I'm being a bit silly.
Can you see the screen?
Gotta go.
We can't see
I'm
anything.
I'm behind. Yeah, I can see the screen. So I'm on the end, like at the end of Greenacres Drive. I'm over the back there, and I run along to, I'm 22C Travis Road. Hang on,
oh, okay. So your home is on a different.
Okay, so I'm
The
at
other end.
there.
You're on a
The
different
road end.
Are you on
No.
a different title to the one we're talking about? Do you live on a different title to the one we're talking about?
Yes, I'm on, but the title I'm talking about is 22C Travis Road, which
Yes.
comes in by the Greenstone end of Travis Road, but our
Yes.
property runs adjacent to this property.
Okay. All right. So, and you still have flooding just like the other submitter?
Yes. Yes.
Okay. All right.
Yeah.
Thanks very much.
Thank you.
Thank you. Ms. Sedgwick?
No questions, thank you.
Thank you. Mr. Fulton?
No, I have no questions. Thank you very much.
Ms. Tiaho?
Nothing from me, thank you.
Mr. Marg?
Nothing from me, thanks.
And Mr. Cooney?
No, thank you.
No, and I don't have any questions either. Thank you, Ms. Byers. Thanks for your submission.
Thank you.
That now brings us to Z and Z Developments. Mr. Shuker, please.
Hello, Mr. Chairperson and Commissioners. Today I'll be presenting on behalf of submitter 114 Z&Z Developments Limited Partnership, who own 102 Travers Road. I thought the directors of Z&Z Developments were going to be present, but it doesn't look like they're here. However, my colleague Angina Lau, who was the project manager on this job, is in attendance. As you've made aware, all relevant documents have been read, so I'll keep this brief and address the main points I would like to raise.
Thank you.
First of all, I'd like to address the relief sought. Due to the 42A report not supporting spot zoning and suggesting that the site is a candidate for more intensive development, I am now seeking the site to be rezoned residential. Council have raised some concerns within their rebuttal about the relief sought and how it may have meant that the submitters would have raised other issues. The concept plan shown in our original submission, in which the neighbours were consulted with prior to the submission being made, showed 1,000 square metre lot sizes. We are now seeking to be included within the Kauwhata West residential area, which the neighbouring residential sites are subject to. This area features a minimum average net site area of 875 square metres. So the 1,000 square metre concept shown to the neighbours is not similar to what can occur on the site if it is rezoned residential. And I'd just like to show a concept plan, if that's all right. Which shows, so this shows the residential development ranging from 800 to I think 1,100 square meters and meeting their 875 density requirement. And so this shows 25 lots, and our original submission had a concept which shows 23. So the change isn't too much different. Therefore, I believe the concerns raised by the submitters who would be similar if a residential zoning was initially sought. All submitters' concerns have been addressed within my evidence. The initial rezoning sought was village, which is an urban zone. I do not deem the residential zoning now being proposed to be outside of the scope of the original submission, as an urban zone is still being sought. Also, the servicing needs will remain the same, and the small increase in density will not create effects which are more than minor. The Section 42A report suggested that the site is a candidate for more intensive development. The site has not yet been developed to a country living density, unlike the adjoining properties to the north. There are some difficulties around developing established country living land to a higher density, which were also raised in the 42A report. The site is currently vacant, so is a good candidate for residential development. Another point I would like to raise is there is an indicative road as shown on the planning maps, which I have up here, running through the site. This has been carried over from the current plan and may indicate past intent for the site to be zoned residential, which would be a better outcome for connectivity. This road would not be developed if the site remains country living due to the cost and practicality. If the site is rezoned to residential, then a road can be developed and will help to provide connectivity between the neighbouring residential zone properties. A traffic assessment, which was included in my evidence, has specified that the intersection, which we have shown on here, has specified that a safe intersection design can be provided, as I said over here. In regard to wastewater, the neighbouring site 114 Travers Road, which is zoned residential, which is this one down here, will require a pump system to be installed at some point to service the site when it is developed. Our site will be able to be serviced by a gravity-fed system connecting to this pump system to provide wastewater reticulation to the site. In terms of stormwater, all stormwater solutions will be designed in accordance with the appropriate standards to be on-site and slow released as stormwater design common practice. Designed stormwater solution will be better outcome for the downstream receiving environments than what currently exists on site. Water infrastructure is located along Travers Road. Therefore, the site can be designed and developed within the required 3 water infrastructure whilst providing connectivity that better serves population needs and urban design. Thank you for your time. Myself or Ms. Lau are happy to answer any questions you may have.
Very good. Thank you very much, Mr. Shuckett. We'll see if there are any questions for either of you. Can we start with you this time, please, Ms. Tiaho?
No questions from me. Thank you.
Thank you. Mr. Fulton?
Yeah, no, thank you. But the intensity of that being developed from country living to urban, it appears if there'd still be quite big sections anyway, in line with what was originally planned for TK and to the, you can tell me how big those sections were, but it appeared quite large sections as well, are they?
Yeah, so those, you mean the concept plan I showed?
Yes, yes.
Yeah, so that ranged from 800 to 1100 square meters.
Yeah, yeah. And that's in keeping with the original structure plan for TK. That's what I would be thinking. Is that correct?
Yes, I believe, yeah.
Okay, thank you.
Thank you. Ms. Gibb?
Yes, is it the development of that property reliant on the next door neighbour property when you were talking about gravity feed to a pump system? So they have to develop as well. Is that right?
I might ask Miss Lau if she's there to answer this. She is a bit familiar. Is she there?
She is, yes, there she is.
Yeah, thank you for that. The intention would be to not be codependent on the adjoining residential to be for their wastewater. I believe we are within 1 kilometre of reticulated council system, and the whole of our site or subject site can be gravity fed. So it would be a couple of options could be looked at by our clients if they wanted to not wait for the next door to be developed, whether they fund fully a wastewater system to account for their development, or whether we enter into some kind of cost sharing agreement on a pro rata basis, considering that the adjoining residential is still to come, and fund it that way. There are a few options to look at. In the greater picture of things, we wouldn't like to be dependent on them, but if they have to come first due to design constraints, then that would be something we'd look at.
And we have plans for the stormwater and the flooding issues.
So our site is upstream of the flooding properties, and there's a existing waste stormwater easement going through the property that's registered. Under the current RITS and stormwater standards requirements, we have to engineer to do the pre-development treatment and keep it post-development flows have to be have detention, and we believe the sites are going to be large enough to be able to cater for stormwater on-site treatment and only treated water to be released to restrain or to not cause an effect downstream that would be at a significant detriment to downstream properties. So currently water is running down the registered easement freely, and where it would, when we develop it, we would obviously look at on-site and treated drainage. We believe it would make the stormwater issues better because of engineered solutions.
Okay, thank you.
Thank you. Mr. Mark.
Yeah, just I'm not too sure, Mr. Shuker, if you heard Ms. McCartney this morning earlier on, she stated in relationship to your original request, a village zone she would accept, but if it was to move to residential, she referred to maybe a plan change would be the most appropriate tool to be looked at. What's your comment to that?
I suppose, well, I suppose if we, because I think she said that is because we didn't, our initial submission was for that village zoning. So a lot of our the things related to the village zone. But however, I think in terms of the densities and what we have proposed with that village zoning, it is pretty similar to that Te Kauwhata West area and their density. So the points we have actually raised within our submission and my evidence would be similar to what would have been raised if we initially proposed that the residential zone.
And just to clarify, you're referring to the Te Kauwhata West overlay.
Te Kauwhata West, Te Kauwhata West residential area overlay, yes.
Yes, and you are aware that she's also stated that that's probably fair to say past its time.
Yep. Yep.
And your thoughts to that, your comment to that?
I haven't looked too much into that in terms of whether that is the case but I suppose, and I know obviously previous submissions we've heard today that a lot of people have said around keeping that character of Te Kauwhata and keeping the larger lot sizes is important. So yeah.
No, very good. Thank you. Thank you very much.
Thank you. Ms. Sedgwick?
No, I have no questions. Thank you for the clarity of your report.
Mr. Cooney?
Councillor, Commissioner Mark answered my questions. Thank you.
Thank you. And I have no further questions either. Thank you, Mr. Shuker.
Thank you.
Thank you. I'm just going to ask that we take about a 90-second break. We'll resume in about just a couple of minutes. Please, no one go away. Very good. Thank you, everybody. Sorry about that. We're now due to hear from Kauwhata Land Limited, please.
It is on mute, so you can.
Where's the?
You can start talking.
Okay, thanks. Can you hear us, Commissioner?
Yes, we can. Thank you.
Sorry, we're collectively here, but using a different name. It's been an interesting morning listening to Ms. McCartney's opening, and we note that her position has changed since her rebuttal evidence, although she did note in her rebuttal evidence that she recognised that there were good planning reasons to support the position that of the Te Kauwhata Lands submission. There's been comprehensive evidence and legal submissions, and as Ms. McCartney's noted, this has already been at the residential zone hearing and now again at the rezoning. The point I would make on that is that this is about removing an overlay from a planning map, and in my submission that clearly puts it within the rezoning hearing. Mr. McKelly made alternative submissions, so that one of the submissions is to remove the overlay completely, and that's the tidiest solution to achieve the outcome he's after. But in the alternative, if that overlay was not to be removed, then he wanted changes to the residential zone rules. So hence here them being heard in the two different hearings. Removing the overlay would achieve the average size standard of 875 metres squared. It would reduce the minimum size standard from 650 to 450 square metres. Just picking up on the point that Commissioner Sedgwick has made, in my submission from the outsider looking into the subdivision, you're not going to notice an awful lot of difference in what you will see. It's not the difference between residential and rural residential. It's the difference between a minimum of 450 and a minimum of 650. And from the outside looking in, it is going to be very much a residential subdivision, regardless of the overlay. In my submission, there's no planning policy or case law reason to reject this part of Mr. McKelly's submission. That Environment Court decision was 12 years ago under different planning environment. There was no NPS UD or NPS at all at that stage. The RPS didn't include the new future-proof provisions. So the entire planning environment that Environment Court decision contemplated was quite different. This is a site that within that Waikato 2070 map that Commissioner Mitchell had up earlier, this is part of the residential part. So it's not the part up by Vineyard and Travers Road that had the larger lots or the lifestyle lots. This is firmly part of the residential lot. In response to to some of the questions from Commissioner Fulton, and I'd note that there is a requirement in section 74 of the Act for the consent authority to make decisions on district plans in accordance with a number of documents, including in accordance with a national policy statement. So that's not a discretion. There is a requirement to make decisions in accordance with that. And in my submission, that national policy statement applies to Te Kauwhata. It is one of the areas within a district that is seen as a high growth area, and it falls within the outer time limit for growth that's caught by the NPS. I also note that in terms of the planning framework that applies to making rezoning decisions, reliance on a historical environment court decision is not one of the colonial vineyards criteria that was set out in the opening submissions for Waikato District Council, the appendix to Ms. Parham's opening submissions. I'd also note that the Te Kauwhata West structure plan is not actually in the proposed plan anymore. This overlay is still referred to in a few of the rules, but the structures plan itself doesn't appear. So it's not a case of this not being in accordance with the structure plan, because the structure plan's gone. And in fact, one of the previous recommendations from one of the council's planners was to remove all references to the structure plan and instead just refer to Te Kauwhata West in relation to the overlays. Mr. Duffy, I think it was, referred to character of the village as maybe being one of the reasons for retaining a difference of section sizes in the Te Kauwhata West area. We note there's not been a single submission that has requested that. There's no submission opposing the Te Kauwhata lands submission. There's no evidence opposing the Te Kauwhata lands submission. There's no evidence before the hearing that this will affect the character of Te Kauwhata village. In my submission, there's no ecological, cultural, or amenity reason to retain a medium density overlay over this piece of land, given where it lies right in the middle of that Auckland to Hamilton corridor. And unless there's some questions for me, I'll hand over to Mr. McKelly and to Mr. Kirby McLeod, sorry.
I think what we might do is, I mean, the evidence is clear and we've read it, including, well, all of it. I think we might just go straight to questions unless there's something that you specifically want the witnesses to highlight for us, and then we can just do a round table on the questions. I mean, the issues outstanding well, there aren't any particularly as between the staff and yourself. So,
Commissioner, I think having listened to what's happened this morning, Mr. McKelly may have some comments that he wants to make, particularly in relation to the adjoining site.
well, that's fine.
Otherwise,
well, let's do that. But I don't think, unless there's something that the others specifically want to raise, we're content just to see if we have any questions, I think. But by all means, happy to hear from Mr. McKelly.
Thank you, sir. It's really just to reinforce the point around the neighbouring Boldero block that's subject to the submissions from Campbell Tyson, and that our submissions and evidence cover that block of land as well.
Yes.
We've been working together with them on a potential joint venture in terms of developing that site. Their development is largely contingent upon us developing our site, because effectively their services will flow down into our site. So it's a bit of a truck and trailer scenario that by combining the earthworks and the infrastructure development, we can more effectively develop both sites together. So I was just wanting to reinforce that point, and it has been addressed in submissions, and we're confident that there is scope, etc., around that. But that might also lead to some questions from the panel.
All right, that's fine. Thank you very much, Mr. McKelly. So let's just proceed with questions, I think. Can we start with you, Mr. Maher?
Yeah, look, thank you, gentlemen, and Mrs. Forrett. I have no questions. It's very clear to me.
Thank you. Ms. Te Aho?
I don't have any questions. Thank you, team.
Ms. Sedgwick?
I just wondered if you had a comment on a point that this 42A report writer mentioned, not in relation to your specific land, but in relation to something that had been equally in the Environment Court, which is she had felt that a change proposed would be inappropriate and effectively disregard the Environment Court ruling. And I'm wondering if you have a comment on how you, because I understand your land is also subject to, or the site is subject to that Environment Court ruling, which Dr. Forrett calls historical heritage, one or the other. What's your comment on that? It seems to me an interesting mix.
If I may, I'm sure Dr. Forrett will have a comment, but we may be in the middle of a fire alarm right now, so we're just...
we can hear there's an alarm going off in the background, but apparently it isn't the fire alarm, so we will just box on.
Make sure you're safe.
In answer to your question, from my opinion, we respect the fact that there is an Environment Court decision that related to the establishment of the Kauwhata West residential zone. However, and as has been pointed out in the submissions and in my evidence and in the planning evidence, the world has changed markedly since that point in time. And I mean, just on that point, I look at the press release that Minister Parker released with the first round of the RMA reforms that they're bringing out, and they're talking specifically to housing affordability. They're talking specifically to housing design. We're seeing the Ministry of Housing and Urban Development going to be given significant powers in order to enable development and infrastructure, and with a $3.4 billion fund that's been put aside for it. The world is entirely different, in my opinion, from when that decision was made. I mean, if we look at when that structure plan was developed, it was at the tail end of the global financial crisis. I mean, 12 months ago, as a land developer, with the onset of COVID, we were busy mothballing our sites. We thought, you know, every economist was telling us it was all about to go south, and we have been scrambling ever since to meet demand, and we have the borders closed. And I mean, if I look at the median house price in the Waikato district, has gone up $86,000 in the last 5 months. That's a 13% increase in 5 months in the Waikato district. The world is different. And I mean, we respect what was done. We respect the Kauwhata village, and our aim is to create the best development possible. But we aren't in a space that was around 10 years ago when that decision came out. So we're reacting to the current situation and what we see going forward, which council's evidence says the growth projections are undercooked. We're also coming up hard against the national policy statement on the retention of urban land, rural land values or soils, which says that we shouldn't be expanding into the countryside area. We shouldn't be expanding into the rural land. So our villages and towns are going to become more compact urban forms. And we've seen that through all of the work done on the unitary plan, but we've just been told we need to evacuate. So we will return as soon as we can, I think. And that's the end of my answer. So,
well, let's.
I have more questions, but maybe we should wait till they finish their fire.
All right. Well, we'll see you back when you can come back in. We'll move on then to hear from Ms. Brown regarding her property at Plantation Road. Thanks.
Yeah, but it'd be good to know. Oh,
if you could turn the microphone off, please.
They gone?
No, not yet. Well, no, just wait one moment, please. We just want to get that siren off the. I think it's gone now. Let me check. Where have they gone? I think they've left in their entirety, haven't they?
I think they have, yeah.
Yeah. Oh, well, we'll see what happens when they come back. All right, thank you, Ms. Brown, just when you're ready. Thank you.
Okay, well, good morning, Mr. Chairperson and councillors. Thank you very much for slotting me some time in this morning. The communication from council has been amazing, but for somebody who's not in the know, it's a little bit baffling to know when to get stuff in. So I do thank you very much for allowing me the time this morning. What I'd like to talk to is our submission to amend the zoning of the two properties at 42 Plantation and 20 Plantation Road at Kauwhata, from the rural zone to countryside living. At the moment, the current district plan, the proposed district plan, really has no provision for any additional countryside living. Pretty much all the lifestyle blocks that have been the backbone of the growth of Kauwhata to date is pretty much sold, with very little that I can see coming online.
And that's your property there, isn't it, on the that I'm just moving the cursor around just so that we're all clear, that one there?
Yeah, so the two properties is that one and then the one that backs onto Rodder Road just above it.
Yeah, this one here.
Yeah, so that sort of whole block there, which is about 45 hectares-ish in total.
Okay. Thank
you.
So
as seen, and I think one of the submitters earlier on was saying, you know, how big the demand is for lifestyle blocks in the Kauwhata community, and this is what's driven the growth. We do currently have, obviously, a future supply of, I think it's about 2,500 residential sections coming online in Kauwhata, which is obviously the lakeside stuff, the Phillips Swan Road, out the back of Blunt Road, leading up to Travers Road, and then obviously the proposed new block as well down by Rongapai Winery. So that's a massive change. You know, it's quadrupling the size of Kauwhata, but there's no provision for countryside living that I can see. Please explain if I'm wrong. And the backbone of Kauwhata predominantly has been a rural community. We know that it's going to change, but it would be sad to miss a good diverse community within the area. The land, the subject property is basically relatively small. It's unproductive in a rural sense. And it is very well serviced with extensive road frontage. The power and water supply runs along two sides of the property. It has existing vehicle access, water meter connections are there. The transport and water reticulation supports the proposed rezoning to country living zone, and the storm and wastewater can all be accommodated on site, and the infrastructure is self-sufficient, so there's no additional cost to council there. The roading has all been recently upgraded through Rodder Road and Plantation Road, and its access is very close and convenient to Te Kauwhata Township. Basically, the proposed rezoning will enable additional housing development and growth from a diverse population level, and thus bringing more business owners to the township, which is currently in an underutilised block, which is restricted by its zoning. The basic subdivision plan, which we've had drawn up at this stage, it probably could be subdivided smaller, but I've based it on 37 new titles for the area. It does, from the WRPS section 105, it does tick quite a number of the boxes there where there is demand. There's no conflict for the land as it's not suitable for high density urban, and there is currently land identified for this. The land is the land is surrounded by lifestyle blocks and sort of neighbouring, bar the motorway, to the existing countryside living zone. The enabling a more intense lifestyle subdivision in one area will stop, obviously, or reduce smaller blocks being taken off more productive land. So it's actually centralised development. The visual effects on the rural character would actually be enhanced by the development. And obviously that would be through planting of wetland and gullies and things like that as well. It does also tick the boxes for hold on a second. Sorry, I just lost myself a little bit with if it's the future urban or the current plan. Hold on a second. I'm just jumping now to section 1.51, whereas the property contained in this proposal has infrastructure and services that can be efficiently and economically provided. We've done the imbalance. Sorry, I'm just going through there. Here's the future-proof strategy. So yeah, it really just does fall in line with the future-proof strategy where you're developing the unproductive soils. The area is heavily populated already with lifestyle blocks, so you do have the reverse asset sensitivity issues addressed. I think that's probably as much in a nutshell that you would need at the moment. Most of the rest is just talking about the reverse sensitivity, the wetland planting in more detail. Yeah, thank you for your time.
Thank you, Ms. Brown. We'll see if there's any questions for you. Can we start with you, please, Ms. Gibb?
No, Ms. Brown, thank you very much for your presentation.
Mr. Fulton?
Yeah, just a comment about the location of this application for country living in that particular part of Te Kauwhata.
Yeah.
It's not bordering on, or it's not even attached to anything. It's a spot zone out in the rural district, isn't it, really? I mean, it's got no association with TK at all, in my view. I mean, you'd be 6 or 8 Ks from TK village.
I don't even know it's that much. about 3 minutes in the car to get into town, and the new overbridge is there. You can actually walk to town from Te Kauwhata. I think if you look at what's happened at Pokeno, where you have the main road intersection and massive development on both sides of the motorway, which actually works. I don't see it's disconnected from the town for the type of properties that you're talking about. My son bikes into Te Kauwhata from where we are. It takes him 8 minutes. So yes, there is a motorway dividing it, but because it's already larger lifestyle blocks and a lot of that area of Plantation Road and going up to Hall Road, it's already lifestyle blocks and unproductive land, and that's the kind of current zoning, but it is very quick into town.
Okay, thank you.
Thank you. Ms. Sedgwick?
No, nothing for me. Thank you, Ms. Brown.
Mr. Marg?
Yeah, just a couple of questions in relationship to both properties. What is the total area?
Oh, the total area, we are 32 hectares and he is 9. So it's about 40 something hectares. I have got it here somewhere. 44 hectares.
So which one is which? Like the 42 plantation is 39?
Yeah, so the 42 plantation is the bigger block.
Right.
And
Thank
then the plantation is about 9.7 hectares, something like that.
And when you say it's unproductive, what's it currently being used for?
It's currently being used for grazing.
Okay. Thank you. That's all.
Thank you. Ms. Tiaho?
No.
Mr. Cooney?
No, thank you.
I've just got one, Ms. Brown. My recollection is, and I could stand to be corrected, but doesn't the 240 kV line run across that property, or at least one of them?
Yeah, as it does at Pokeno, but the setbacks are well within developable.
Okay.
Yeah, you could easily develop around those setbacks, but it's exactly the same as it runs through Pokeno. But this is actually lower density size blocks of lands, whereas at Pokeno they're almost pretty much under the pylons, which we wouldn't need to do. But
I understand. I just wanted to make sure I understood that properly. Thank you. All right. I don't think we have any more questions for you. Thank you very much.
Thank you again for your time and for slotting me in, and hopefully I'm prepared enough for you.
No, that's been helpful. Thank you.
Thank you.
We now have the problem that we've got a submitter who's gone AWOL due to the fire alarm. So I think we're just going to have to sit tight for a minute or three. I'll mute my, people are free to. Sorry, I muted myself too early. I'll just mute and keep my eye on the screen and give everybody a.
I'm happy to fill the spot, Mr. Chairman. I'll be very quick.
You're not on the list to be heard, I don't think, are you, Mr. Duffy?
Sorry.
Excuse me, Mr. Mitchell, they are back in the boardroom.
Excellent.
Oh, they are. Mr. Duffy, just before we do that, were you expecting to present to us, Mr. Duffy?
No, Mr. Chairman, other than to say that Lakeside, look, just wanted to register an appearance, support the 42A report, happy to answer questions. But if
we understood that. Thank you. So I don't think we have any questions for you, but
thank you. Then I'll
thank you for that
meeting, and thank you for your time.
Yep.
Thank you.
Thank you. Lovely.
Right, looks like the fire's been put out, has it?
Yes, no self-respecting fire would burn in those temperatures.
You're absolutely right.
It's a lovely sunny day up here, but never mind.
It's sunny here. It's sunny here above the fog as well.
So
it always is if you go up far enough.
It's a normal day, is it?
Apparently, yes.
It feels a little bit like that in Waikato. I think if
Ms. Sedgwick, you still had further questions, I believe.
Mr. McCully had answered my question. My final question is that my understanding is that the two blocks of land that the block of land that you're talking about is your residential land, and the block that we can talk about with the connecting road, the Brigato block, if you like, the other side, the Waikato block, were designed or intended to be designed in a complementary fashion. Do you feel you can still meet those standards given the removal of the overlay?
Yes, is the very short answer to that. Yes, and we have plans to develop them in an integrated way and retain the connection framework that was in place. So a connection through to Tikawhata Road and into the subdivision and through our subdivision and to the reserve area and what have you would all be part of the development of both blocks.
And thank you. Sorry, and the Hilltop Reserve that was indicated that has some cultural significance to the local mana whenua, that still remains and retains its status?
Yes, there's the reserve area is defined on the planning maps.
Good. Thank you very much.
Thank you.
Thank you. I apologise, I've lost track of our order of questions. So if you've already asked questions when I ask, please just say so. Sorry, I've got a system here, but it doesn't work when someone gets interrupted and we move on to another submitter. Mr. Marg, have you got any questions?
No, there was nothing from me. Thank you.
Ms. Tiaho?
No, thank you.
Mr. Fulton?
Yes, just one question. Ms. McCartney, this morning when I asked her the question on the, or indicated that the NPS and UD wasn't the only document or in the other intensification didn't necessarily trump the Environment Court's decision on Tikawhata West. Now, this is a district plan review and it's about the intensification and making the urbanisation in a much more intense manner across the whole of the district. But we can have some areas surely that are not quite as intense as others. And TK has got a structure that is not as intense as most of the other urban towns that we're dealing with. This would be, to my view, a much more intense than any other part of TK could ever develop. And it would look a little bit, and probably supporting Councillor Sedgwick's view that it would be an area that would be quite intense and the rest of it being not so intense. Have I summed that up correctly? Is that the way you see it?
The zone we've requested, or I've requested be applied to the site, is the standard residential zone that applies to the balance of Tikawhata as outside of those areas that the Tikawhata West overlay is proposed to be applied to. So if we look at that, I'm only proposing to reuse an existing zone which is going to be applied to other parts of Tikawhata. And in doing that, lifting the overlay that's there as the planning mechanism to achieve it, because the site is zoned residentially. It just has an overlay over the top, which rolls over the previous subdivision standards from the operative district plan. So I don't see it as being anomalous at all. And in terms of how Tikawhata has developed, the only area that has developed in accordance with the Tikawhata West zone or overlay is the Waikato estate. And that is largely sitting in a pocket by itself. Can't really be seen from Tikawhata Road as you drive in. And if we look at the other sort of more significant development that has occurred in the Tikawhata West zone, is the Travers Road subdivision. I can't remember which name it goes by now, but actually via the consenting process, those lot sizes were are down in sort of the 600 and 700 square metre sort of area. So the zoning hasn't actually really been given effect to, and I would suggest that what you will see is what has been spoken to. You'll see residential development as you drive into Te Kauwhata. The density might be slightly more, but I wouldn't personally believe that you'll see any great difference, and it won't undermine the structure of the village. And in terms of accommodating density or accommodating numbers of people, etc., that is to a degree being mandated. The regional policy statement says that urban areas or residential areas should be accommodating 12 to 15 households per hectare. We can expect that to go up. I know of plan changes being prepared at the moment for urban areas where they're talking about standard residential densities of 20 to 25 dwellings per hectare. But also be mindful that your village structure is supported by your country living zone. And if we look at what the decision of the Environment Court said, it said that the transitional element is provided by way of the country living zone, not the residential zone. And this has been our contention, I would suggest, all along, is that we feel that there's been a mix of the application of the outcomes of that decision in the zone rules. There were specific requirements on the zone boundary between the Te Kauwhata West zone and the country living zone, but the Environment Court decision is very clear that the transition from urban to rural is provided by way of the country living zone. So a very long answer to a relatively short question, but as I say, we're in a very different environment than what we were in that time that decision was handed down.
Okay, thank you very much.
Thank you. Mr. Cooney?
Dr. Forrett, would you agree with me that a Environment Court decision doesn't act as a precedent in terms of future planning?
Yes, I would, Commissioner, in respect of rezoning and plan making. Certainly, and it can't. The rezoning and plan making process is based on a number of things around that whole Section 32 process, and takes into account those the documents that are set out in the RMA, and to the extent that a previous Environment Court decision may help interpret how rules or so forth apply, yes, but not in the planning context, no.
Okay. And in terms of the NPS-UD, we've heard arguments from various council that the urban environment can be considered in the context of providing housing or a labour market of at least 10,000 people would apply to Hamilton or Auckland, and therefore the smaller areas around all provide housing for that labour market. Do you agree with that sort of argument?
Yes, Commissioner, certainly.
Yeah. Okay, and I think also the NPS-UD provides for a change in amenity as well within different areas. You're aware of that?
Yeah, it does provide for changes in amenity. Although having said that, in my submission, the amenity in this particular site is not going to change that much. And as Mr. McKellie said, the residential zone rules apply to all of the urban part of Te Kauwhata anyway, apart from this relatively small overlay area.
Yep. Okay. Thank you.
Thank you. Ms. Gibb, do you have any questions?
No, nothing, thank you.
And I don't think I have any questions now either. Thank you. They've been asked and answered. So thank you very much.
Thank you, panel.
Thank you.
Thank you.
That brings us to the end of what we were anticipating getting through today. So it suffices to say two things. Firstly, Ms. McCartney, if we could get a reply statement from you over the course of the next week or two. We're not particularly fussed as to the specific timing of that, but that would be helpful, please. The second thing is just to thank everybody for the way that they've presented their information to us today. We found it very helpful. And I think without further ado, we'll adjourn. Thank you, everybody. If the panel wouldn't mind waiting for a moment, please. Thank you. We're adjourned.